The third pillar of estate planning is protecting your assets from long-term care. If you've been following the program, the first and second pillar were the revocable trust, the basic estate plan, the inheritance trust to keep it in the blood. That's the estate planning portion. And many fine estate planning firms do address all those issues and cross those T's and dot those I's. But unfortunately, only a tiny percentage of them are also elder law firms, and they generally do not take steps to protect the assets of a nursing home. So what happens? The client has a beautiful estate plan, avoided the probate, avoided the guardianship, avoid the out-of-state probate, save the estate tax, keep it in the blood. But unfortunately, the client then ended up in the nursing home, and the nursing home got all the assets. The family got nothing. That reminds me of the old saw. You know, the operation was a success, and you know the rest of that one. Well, what's the use of an estate plan if at the end of the day there's no estate left? So we feel for the estate plan to be effective, it has to have some way to protect the assets from nursing home. So that's the third pillar, and if you're with our firm, you'll have it because it's a major part of what we do, the elder law portion, the nursing home asset protection. Now, there's really only two effective options here, so you end up with one or the other. Let's look at your two choices. First, long-term care insurance. Long-term care insurance, we believe, is the way to go if you can get it, primarily because it helps you stay out of a nursing home. Do you know, a lot of people today end up in a nursing home because they simply ran out of money, could not afford to stay in their own home. We like the long-term care insurance so we can age in place, is what it's termed. I want to be able to stay in my own home as long as possible. With the long-term care insurance, you may be able to stay in your home for years or a decade or more longer than if you didn't have it because it stretches your dollars. So long-term care insurance if you can get it. Also, if you're a couple, unfortunately, we like long-term care insurance if you're a couple because unfortunately, sometimes later in life, one of the spouses becomes disabled. The other spouse finds out fairly quickly it can cost $4,000 or $5,000 a month or more to bring somebody into the house. And they quickly realize that if they start spending that kind of money, what are they going to have left for themselves? So they say, I'll do it on my own. Now, Alzheimer's Association did a study a number of years ago. It was in October of 2003, and they found that over 60% of spouse caregivers are dying first. Why is that? Well, the simple stress of a 24/7 job in your 70s, 80s, or older, and it's a very difficult job. So it can wear you out, put you in the hospital or worse. We see it in the practice. With the long-term care insurance, this tends to be much less of a problem because if you're not out of pocket, you can call in the help. Somebody else does the heavy lifting. You supervise naturally, but you not only don't wear yourself out, but you also get respite. You know, you get away from it. Perhaps visit a relative or go and see a movie. So you recharge your batteries. So long-term care insurance, if you can get it, one of the things we do when a client comes into the office as an elder law firm, we address that issue. Are you getting the long-term care insurance or not? And here's why we want to know. Because we feel that if you're getting it, you want to get it while the getting's good. And by that we mean while you're still insurable. Before you or I or anyone else goes to the doctor and they say, I'm sorry, Mr. Smith, Mrs. Smith, you have this, that, or the other thing, and you're either not insurable anymore because of medical condition, or you are insurable, but the premium has become prohibitive because of the increased risk to the insurance company. So get it while the getting's good, and of course, the sooner you get it, the less expensive it is. Now, it's true, if you're younger, you make more payments, but at the end of the day, the total that you've spent is still much less. So get it while the getting's good. But we also need to know if you're not getting long-term care insurance. Some clients come in and say, Mike, we looked into it, it's too rich for our blood. And many people come in and say, well, we applied, but they turned us down. Or if it's a couple, they'll say they turned one of us down. Well, if you can't get long-term care insurance for medical or financial reasons, then in my view, and the view of the Ettinger Law Firm, it's imperative that you look at the Medicaid Asset Protection Trust, MAPT. It's an irrevocable trust, and I'll explain the difference in a moment, but the Medicaid Asset Protection Trust is the one you set up 5 years ahead of time. So if unfortunately one day you have to go into a nursing home, they can't touch your assets because the 5 years has passed. So for example, you put your house into the Medicaid trust anytime after 5 years. If you have to go into a nursing home, they can't touch the house. But what happens if you don't make the 5 years? 4 years go by, you have to go into a nursing home. In that case, you only have to pay for the 1 year that's left. You already have the 4 years under your belt. In other words, it always pays to get started, even if you don't make the 5 years. Now, I mentioned it's an irrevocable trust. What does that mean to you? Well, here are the differences between a revocable and an irrevocable trust. I mentioned in the first pillar, in the revocable trust, you, Mary, are the trustee. Well, the revocable trust doesn't protect your assets from a nursing home, because if you're the trustee and you're in charge, you can take it out. So if you have to go into a nursing home, let's say, Mary, you're in charge, take it out and pay for your care. In other words, if you can get it, they can get it. In an irrevocable trust, in the Medicaid trust, you actually set up two roadblocks that Medicaid and nursing homes simply can't break through. First, you name somebody else as the trustee. People almost always choose one or more of their adult children. Medicaid and nursing homes have no control over them. The second pillar is, in this Medicaid trust, you must limit yourself to the income only. You put in stocks, you only get the dividends. You put in CDs, you only get the interest. You put in your home, it doesn't earn income, but you get the equivalent of the income, exclusive right to live there, use and enjoy the property during your lifetime. What happens to these assets? They stay in the trust, they go to your heirs, free of the expense and delay of a probate proceeding. Now, who sets up these Medicaid asset protection trusts, and why do they do it? Generally, clients 65 and older have a lot of assets they're not going to spend, like their home. People move to protect their home so they don't lose it. They also move to protect assets they're just taking the income from, because remember, the trust pays out income. So if you're only taking the income from an asset, why not put it in the trust so the nest egg, the principal, is protected and you still get the income, but somebody else can't come and take away the nest egg. We also use it for assets that the client has not taken the income from. They're just reinvesting it. Well, why should it all be sitting out there at risk if you're not using it? Put in the trust, and then still there if your family needs it, but somebody else can't come in and take it away from you. Now, I mentioned that the Medicaid Asset Protection Trust is an irrevocable trust. Well, that's not as serious, perhaps is the word, as it sounds. Because in New York, you can revoke an irrevocable trust. Now, not yourself, you the grantor, mom and dad, or yourself if you're single, you can't revoke it yourself. That's why it's an irrevocable trust. But New York law says if you the people set it up called the grantors, and the people named as beneficiaries to get it after you're gone, your adult children, the people named as trustees to manage it during your lifetime, one or more of your adult children, if everyone in your family agrees in writing that they no longer want the trust, you may revoke it on consent of all the named parties. So you can actually undo it if you need to. Sometimes a client will be moving to another state where they won't need it, or moving in with a son or daughter permanently, may not need it, or sometimes clients decide to move into a life care community where the nursing home is included in the buy-in and they no longer need the trust. So it's nice to know if you don't need it, you can undo it. Which trust should you have, revocable or irrevocable? Well, you don't need both, and there's no right answer. It depends on your age, your health, your assets, your family history. Do you have long-term care insurance? Do you want the asset protection of the Medicaid trust? It's a type of thing we talk about in the consultation in the office. Another word on that irrevocable trust, it really doesn't affect your lifestyle. You still get your pension directly, Social Security directly, interest on your CDs, dividends on your stocks, exclusive right to live there, use and enjoy your home, keep all your exemptions, your senior, your veterans, your star. Now, if you put your home into that Medicaid trust, can you sell it? Sure. The trust sells the house, the money's paid to the trust can go out and buy a condo, it's still protected. Can sell a CD and buy a mutual fund, sell one stock and buy another. The trust can buy and sell and trade. All I said was, you can't take out principal directly for yourself, because if you can get it, they can get it. So, you don't necessarily put every penny you ever earned into the Medicaid trust. What do you leave out? Well, If you have a spouse, you can leave out $100,000 or so, give or take, because if there's a spouse at home, about $100,000 can be exempted. You also leave out IRA, 401k, 403b, 457 plan for state workers. Those retirement plans are exempt from Medicaid, at least the principal is, the nest egg is. They can get the income over 70 and a half. You have to start drawing your required minimum distribution. That they can get, but they can't go into the principal of your IRAs and the like, so you can leave those out. Again, it's the type of thing we talk about in the consultation. So that is the third pillar of estate planning, protecting your assets from the costs of long-term care.